The powerful engines of authority must be prevented from running amok. A statement made with a lot of truth. The rule of separation of powers states that responsible governments require effective agencies to provide a clear, open perspective, stable, and general community rules. It also stated that responsible governments require an impartial and effective body to settle rule-related disputes. However, when powers are delegated to that many bodies, it becomes harder to ensure that such powers are not abused and that they're implemented to the extent or the limit conferred, hence administrative law. Back to the statement made, it is not implied that courts have control over the powerful engines of authority, but only the responsibility of looking over decisions and making sure that they're made correctly. That process is called judicial review, which is in place to ensure that the proper steps were taken to reach the decision made. The courts may not replace the decision with one of their own, but are responsible for ensuring that the legality of the decision made by checking that the relevant procedures were followed as per the law. As a result, decisions get reviewed and returned to the initial decision maker to reconsider a decision. A great example of the interference of the courts is in the case of Padfield and Minister for Agriculture, Fisheries and Food, where a minister was delegated the power to direct a committee to make inquiries into complaints concerning various food products. Basically, a group of farmers complained of a matter which was prejudicial in their region of the country, and that was refused to be referred to the established committee. That resulted in the House of Lords granting an order of mandamus, requiring the minister to consider the decision properly after his decision was challenged by the farmers via judicial review. The House of Lords ruled that while the minister was not obligated to refer every complaint made, neither did he have the unfettered discretion to refuse a case. Traditionally, the main focus of judicial review was on issues of jurisdiction and natural justice, meaning that the main concern was whether a decision was made intra vire or ultra vire, as well as the process by which the decision was reached followed natural justice. As a result, it led to decisions being indeterminate, ambiguous, unpredictable. Poole actually mentions that the era we are leaving of, intra vire, ultra vire, that vagueness, had its core concerns with the examination of powers and procedures, while the era we are entering is one in which rights and substantive review, and I quote, like Cinderella, have escaped subservient positions to take center stage. So if a decision was made intra vire and followed the requirements of natural justice, courts would not interfere with the decision, even if the decision was wrong in some sense. Although the judges still use the conventional vire vocabulary to explain their position, thankfully the method is stronger than previously. If a public body, as defined by the law, commits a legal error, the courts will intervene through the process of judicial review to ensure that the body reconsiders the matter and acts in a procedurally right manner. Now that brings us to the rights-based approach. The new era that Poole previously mentioned talks about the reformation or the reinvention of the review method, hence the rights-based approach. The role of the courts in the safeguarding of fundamental rights was outlined by John Laws. In a nutshell, he proposed a higher level of law that would be binding on the elected parliament, with the courts being the guardians of both fundamental and individual rights, as well as the structural constitutional rights. That would mean that we have to go back to the basis of the protection of human rights by looking at the rule of law. A.V. Dicey describes it in three main aspects: that no man is punishable or can be lawfully made to suffer in body or goods, except for a distinct breach of law. In other words, no one can be punished except for conduct which represents a clear breach of law, and that no man is above the law. And finally, the general principles of the Constitution of fundamental rights of the people. The rule of law is generally held to enclose an attachment to freedom, which is substantive, certainty or the clarity of the law, as well as the fairness, which are both more procedural components of the rule of law. That brings us to the basis to which courts go back to in the rights-based approach. It is unlawful for public authorities or individuals performing public tasks to violate convention rights. According to Section 6, subsection 1 of the Human Rights Act, this, of course, is only applicable subject to Section 6, subsection 2, and Section 6, subsection 3. Section 6, subsection 3 actually specifies what falls under the umbrella of public authority. And surely, courts also fall under the same definition, further emphasizing their role in the regulation of decisions made by bodies with power over citizens, as well as the fact that courts, although entrusted with the function, are still subject to limitations. So any time any part of the ECHR, or the European Convention on Human Rights, or the HRA are breached, action is taken. In this approach, these two act as the first match lit, which builds its way to a bonfire, an attempt to further improve the rigidity and certainty of people's rights. As for remedies for a successful judicial review, they are categorized into three sections: prerogative orders, equitable remedies, and common law remedies. Let's dissect each section, starting with the common law remedies. Damages may be claimed under common law, however, only subject to Section 31, subsection 4 of the Supreme Court Act, which sets out the conditions under which a claimant may be awarded damages. As for the equitable remedies, they can be further subcategorized into two claims, which are a declaration and an injunction, Because the pronouncement has no immediate legal impact, it's not a remedy in a traditional sense, and the declaration is primarily used to settle disputes since it states the court's interpretation of the law on a specific topic. However, an injunction, on the other hand, can be employed as a last resort in specific circumstances. An injunction might be either prohibitive or mandatory in nature. A prohibitory injunction stops a public authority from doing something it was planning to do anyhow, whereas a mandatory injunction forces a public authority to do something it was planning to do anyways. It is important to note that the judicial review is a must if the claimant seeks a declaration or injunction in addition to a prerogative order, as shown in Part 54.3 of the Civil Procedure Rules. Finally, we move on to the prerogative orders, which include a quashing order, a prohibiting order, and a mandatory order. A quashing order, also known as certiorari, is a court order that overturns a government agency's illegal judgment. As a result, the judgment or the ruling is null and void. The prohibiting order can be used to stop a public authority from acting in an illegal manner. And finally, a mandatory order, also known as mandamus, directs a government agency to utilize its powers in a legal manner. As a result, it is demanded when a government agency refuses to exercise its authority.
Hello and a good day to everyone. My name is Jonathan Kim, and today I'll be talking about the statutory grounds for judicial review. So judicial review is a process by which the courts monitor the government's use of authority. Government departments, local governments, tribunals, state agencies, and other agencies with governmental powers must exercise such powers in a legal manner. Judicial review has evolved to guarantee that public entities that have legislative or adjudicatory powers stay within the bounds of their authority. As a result, judicial review applies to almost every area of the Constitution. The Human Rights Act of 1998 broadens the scope of judicial review by making any failure by a public entity to respect human rights subject to judicial review. With this in mind, there are two types of principles that might be failed. Those alleging a violation of the law and those arguing that a decision was made in an arbitrary or unjust manner. The House of Lords ruled in Council of Service Unions against Minister of State for Civil Services 1985 that the grounds for judicial review might be grouped into three categories: illegality, irrationality, and procedural impropriety. Okay. The doctrine of ultra vires is that beyond or the capabilities of decision-making bodies is referred to as ultra-vires. While the courts continue to use the word ultra-vires, it is no longer a broad enough term to cover the entire scope of judicial review. As a result, it may be preferable to think of judicial review as the court's control and regulation of the decision-making process. If the decision maker utilizes his powers outside the authority provided in a manner that is procedurally Wednesbury unreasonable, he is operating ultra-vires. His powers and hence unlawfully. In Lord Brown declared in R against Hall University Visitor ex parte page in 1993. In the case of Hazel against Hammersmith and Fulham Council in 1992, the council attempted to boost its revenue by making a financial investment that were dependent on interest rate fluctuations for success. The House of Lords concluded that the council lacked the authority to engage in merely speculative interest rate swaps. Such speculations was incompatible with the legislative borrowing powers granted to local governments, and it was neither conducive nor incidental to that exercise. Now, I'll be going over illegality. Because there is a possibility of errors in the administrative procedure, the decision maker must exercise some discretion. For instance, the decision maker may misunderstand the legislation, evaluate irrelevant and relevant factors, or follow a rigorous policy. A decision may be declared unconstitutional if it fails to follow the norms of natural justice and fairness. Legality can be defined as errors of law, errors of fact, onerous conditions attached to a decision, using powers for the wrong purpose, relevant and irrelevant considerations in decision making, acting in bad faith, bettering discretion, unauthorized delegation, failure to act, and failure to comply with policy. So in the case of Kawaja against Secretary of State for the Home Department is a crucial case that demonstrates this. It's taken in 1984. The House of Lords debated the legitimacy of detention order pending an expulsion from the United Kingdom as an unlawful immigrant. There was a factual debate over whether he had gotten permission to enter by fraud. The House of Lords ruled that it was necessary to investigate if the applicant was an illegal immigrant before determining whether there was any power to detain with the intention of deportation. Now I'll be going over irrationality, or also known as Wednesbury unreasonableness. So irrationality is a concept that moves the courts away from analyzing and assessing the procedures by which a decision is made and closer to substituting the court's own view of the decision's merits. So, for example, in the case of Associated Provincial Pictures Houses Limited against Wednesbury Corporation is a famous example of this, which was in 1948. The local government had the ability to provide licenses for the opening of cinemas, subject to whatever conditions it saw necessary. When obtaining a Sunday license, the administration stipulated that no children under the age of 15 should be permitted. So the petitioners claimed that the requirement was imposed arbitrarily and outside of the corporation's authority. So Master of Rules Lord Green alluded to the various grounds for challenge to a decision including unreasonableness, bad faith, dishonesty, paying attention to relevant circumstances, and disregard for proper decision-making procedure, and concluded that all of this could be grouped under the umbrella term unreasonableness. So this case popularized the phrase, the authority reached a decision in a manner so irrational that no reasonable authority could ever have reached it. So when it comes to human rights, the courts will scrutinize choices more closely than they would otherwise. So when it came to irrationality, Sir Thomas Bingham took the correct path in R against Ministry of Defence ex parte Smith in 1996. It was stated that on substantive grounds, the court may not intervene with the exercise of administrative discretion unless the court is satisfied that the decision is unreasonable in the sense that it goes beyond the range of options available to a reasonable decision maker. So now I'll be going over the doctrine of proportionality. So this doctrine limits the exercise of authority to means that are proportional to the goal being sought. Other continental European countries such as United States of America and Canada have embraced this concept. The European Court of Human Rights, also known as ECHR, and the Court of Justice of the European Union, CJEU, both use proportionality as a criterion for determining the legality of actions and authorities. Furthermore, throughout recent history, proportionality has been utilized in English courts, and the question continues to be at the forefront of intellectual and judicial debate. So the proportionality principle first appeared in the case of R against Barnsley Metropolitan Borough Council ex parte Hook in 1976, in which Lord Denning, Master of Rules, quashed the revocation of a market stallholder's license for urinating in public on the grounds that the punishment imposed was disproportionate to the offence. The question that comes to mind is, under what conditions might the proportionality test might be applied in judicial review? Domestic courts and tribunals are required by Section 2 of the Human Rights Act 1998 to take into account the judgments and decisions of the courts of human rights, as well as Section 6 of the Act, which states that the courts and tribunals and public authorities under the Act thus have a duty to not violate the Convention rights. The case of R against Secretary of State for the Home Department ex parte Sims is an example of human rights case in 1999. So the Home Secretary's blanket prohibition on journalists interviewing prisoners for the purpose of publishing, based on the argument that such publicity would jeopardize prison administration and discipline, was found to be unreasonable as it violated fundamental rights, particularly Article 10 of the Act. So the conceptual underpinnings and identifying the equilibrium and the burden of proof are three essential distinctions to make when comparing the Wednesbury test to the proportionality test. The first is that the Wednesbury review is concerned with the reasoning process used in making a certain decision, with the main points being the justification stated for that conclusion. So in the context of rights, proportionality refers to the consequence of a judgment. Secondly, compared to the Wednesbury review process, which is a less intrusive and less qualitative process in and of itself, the proportionality review is significantly more distinctive because of the balancing exercise that it requires. The disparity in quality is due to the need for balance. And finally, the claimant must prove that the measure they are challenging is unreasonable under the Wednesbury unreasonableness test. So when a claimant alleges that a measure infringes on their convention rights, the government must show that the measure is proportionate to the goal that it aims to achieve under proportionality review. The courts have adapted to the approach of the Court of Human Rights in employing the concepts of proportionality and necessity, which give greater scope for the protection of rights than the conventional concepts used in judicial review under the umbrella of the Wednesbury unreasonableness test. In exercising the interpretive duty imposed by Section 3 of the Human Rights Act 1998. Alright, to summarize, the Wednesbury unreasonableness concept is ineffective, but it should not be replaced with the proportionality principle. So one reason for this is that Wednesbury is evolving into a super Wednesbury ground, in which courts are reluctant to intervene in cases involving government policy or public expenditure, and instead apply a more stringent of unreasonableness known as super Wednesbury, which is also known as the anxious scrutiny or rigorous scrutiny approach, which corrects certain flaws in the ordinary Wednesbury unreasonableness. Furthermore, it can be seen that the proportionality test is more effective in defending human rights. Proportionality review, which is essentially the crux of the standard review and the reason why it is capable of providing stronger protection to human rights, as it requires the judge to exercise value judgment independent of the decision maker. That is all for me, and I'll be passing on to my friend.
I will now be presenting the legitimate expectation. Courts must determine the existence of legitimate expectation when an individual seeks judicial review on the ground of his legitimate expectation being beaten. As a result of a promise, representation, practice, or policy made, implemented, or publicized by or on behalf of government or a public authority. A legitimate expectation is said to arise. Consequently, it includes a benefit that an individual has gotten and may anticipate to continuing receiving, as well as benefit that he expects to get. When such a legitimate expectation of an individual is defeated, it gives that person the locus standi to challenge the administrative decision as illegal. Thus, an individual can seek judicial review with a legitimate expectation, even when the substantive right is not present. There are two aspects to the doctrine of legitimate expectation, which includes procedural and substantive. In procedural legitimate expectation, it refers to an individual's expectation that he has the right to certain procedure. These rights include the right to hearing because of the behavior of the public body. In substantive legitimate expectation, it refers to a situation where an individual is looking for substantial benefit which came out of legitimate expectation he had. The English courts have issued both judgments that recognize the need to preserve substantive legitimate expectations and ruling that are the opposite. The position of the substantial legitimate expectation must now be seen considering the case of Regina against North and East Devon Health Authority ex parte Coughlin. The brief fact for the case is that Coughlin and the other patients were treated in the New Court Hospital at first. They were convinced to move to the modern house by the health authorities. Explicit promises that they could stay for as long as they like, and that modern house was better suited to their requirements. After evaluating the commitment he had made to the residents and examining all possibilities, the authorities decided to shut down modern house and transport the patients to other hospitals. Coughlin challenged the decision as they breached the promise made to her. The court's role is thus restricted to asking whether the application of the policy to a person who has been led to expect something different is a legitimate use of authority. According to the Court of Appeal, now the test of abuse of power was established as the Wednesbury test was rejected as a test for judicial review of the legitimate expectation of this nature. A much larger scope is given from the test for the application for violating the success of substantive legitimate expectation. The odds of a successful judicial review would be almost non-existent if the Wednesbury test was applied. Next, I will be presenting on the rules of natural justice. Now, the rules of natural justice are that of common law rules, albeit their requirements can be rendered statutory in many cases. The fundamental principle of justice is that individuals who are impacted by the decisions should be treated fairly. There may be various prerequisites that must be met for something to be accomplished. This is evident in the case of R against Commission for Racial Equality ex parte, Quattro and Rotten, 1980, whereby Lord Lane CJ stated that the standards of natural justice simply indicate that processes must be performed in a manner that is fair to all situations, as has been said many times before, and there is no harm in repeating it. It was also emphasized by Lord Bridge in Lloyd against McMahon, 1987, that the rules of natural justice are not rigid and determinate. It was stated in the case that the so-called natural justice laws aren't carved onto stone tablets. What the requirements of fairness demands when anybody, domestic, administrative, or judicial, must make a decision that will affect the rights of individuals depends on the character of the decision-making body, the types of question it must make, and the statutory or other framework in which it operates. To use the phrase that better expresses the underlying concept, Article 6 of the European Convention on Human Rights, which is now enforceable in domestic courts under the Human Rights Act 1998, refers to the principle of fairness. Article 8.6 mandates a fair and public hearing by an independent and impartial tribunal constituted by law within a reasonable period. Have been charged with a crime. You have the right to a fair trial to establish whether you are guilty or not. This is a universally acknowledged human right. Fair trials aid in the discovery of the truth are essential for all parties engaged in the case. They are a cornerstone of democracy, assisting in the creation of fair and just societies, while also restricting government and state authority abuse. Every person should be presumed innocent until proven guilty, which is a fundamental principle behind the right to fair trial. However, there are some instances in which this right is violated in practice. Mass surveillance, the use of artificial intelligence to profile people, oppressive policy methods, and pre-trial detention all weaken the presumption of innocence. It is the state's job to show that someone is guilty, not the burden of the persons accused of a crime to establish their innocence. It is also the state's job to establish why someone should be held. People should not be pushed into a meeting, to a crime, or incriminating themselves by harsh interrogation techniques or the prospect of further punishment for exercising basic rights. In general, exercising one's right to quiet should not be used as a proof of guilt as a basis to place them in pre-trial custody. Nor should it be punished. Being convicted of a crime can have substantial and even catastrophic implications for the person who has been convicted, their family, and the larger society. As a result, nations must demonstrate that a prosecution is required before proving guilt to a high standard. An accused individual must be given the benefit of the doubt and judged not guilty of the allegation if there is reasonable doubt. Trials should be held as soon as possible to ensure that justice is truly delivered. This protects the integrity of evidence and reduces the human toll of criminal procedures on all parties concerned. Efficiency, on the other hand, should not take precedence above fairness. To wrap up this presentation, we look at how much the requirements and grounds of judicial review support the judiciary's power to defend basic rights, as well as the limitation to that ability. Our assessment of the court's role and suitability as guardians of said rights also reveal that Poole's theory of a legitimate-based approach falls short of fully reflecting the nature of judicial review process, which by its very nature necessitates normative judgment of moral and legal issues. As a result, we conclude that the courts act as a defender of basic rights through the application of the right-based conception of law in the judicial review processes only to the degree that the Constitution structure permits. Thank you very much. That's all for our presentation.